I totally forgot to hit record. Let's do that one more time. Welcome everyone to the January 2023 edition of the Employer Handbook Zoom Office Happy Hour. My name is Eric Meyer. Thank you for joining us. We're here today to talk about what's hot at the EEOC, and I have with me a very special guest, EEOC Commissioner Andrea Lucas, Commissioner Lucas was confirmed to the EEOC in 2020. Her term expires in a couple of years. She was previously a member of the labor and employment litigation practice groups of Gibson Dunn and Crusher LLP in the firm's DC office. And while at Gibson Dunn, Commissioner Lucas was a management side employment lawyer. So you are getting the benefit of not just an EEOC commissioner, but someone who has been in the trenches, just like all of you folks. Commissioner Lucas, thanks for joining us.
Thanks for having me. I'm delighted to be here. And yeah, as you said, the management side, I think, has given me a really round perspective on this. I've got some passions on things that might be a little more plaintiff side, and then a lot of perspective about the management side. So I'm enjoying the time here.
Wonderful. Well, thank you. Thank you, Commissioner Lucas. Let me do a couple of disclaimers. First, Commissioner Lucas and I are not giving out we're both lawyers. We're not giving out any legal advice today. We're not creating any attorney-client privilege. And Commissioner Lucas speaks on behalf of herself and certainly not the full commission. Folks, if you want legal advice on any of the topics that we are discussing today, call your lawyer. Don't take free advice from a Zoom where you have to pay for anything. Hopefully you get more than what you paid for, but we're not giving out legal advice at all. But if you do have questions, and let's make sure the chat is working, put them up in the chat. And we'll get to as many of your questions, your non-legal questions that you are asking hypothetically for a friend as we can. But we have a pretty full schedule here. Let's see. Let's level set. Commissioner Lucas, for those who aren't in the know, describe the setup at the top at the EEOC. What does it mean to be a commissioner? What is your role? That kind of stuff.
Sure. And it's not even those who aren't in the know. I feel like, I was a member of the management bar for around a decade and somehow really didn't fully grasp what the commission level did even still. So it's pretty easy to not fully get it. So the commission is made up of a bipartisan 5-person panel. But what we actually do, I think, is the mystery there. So it's a interesting mix of a lot of voting. So we'll review every single case that the commission files. Some of them will be voted on. We voted on a higher percentage in the prior administration into this one, and that may be changing. So we can save that discussion for a little longer. We're also going to vote on any policy documents that are formal policy documents, as opposed to a technical assistance document. That's also another caveat we should talk about. And then there's some level of oversight. The degree to which people think of that varies depending on commissioner, but I think it's important as the head of an agency who has sort of a direct line into Congress and accountability to have some level of oversight there too. And then there's the independent powers of the commissioner. So I can bring commissioner's charges, which are something that doesn't require any vote by anyone and reflects my own decision to bring that, bound by something akin to a Rule 11. That's so I'm standing in the shoes of a charging party, and then there's the whole range of kind of choose your own adventure, which like I describe it. This is one of those things: doing outreach, doing education, awareness of what the mission of the agency is, what's happening, reaching out to stakeholders like employers and as well as plaintiffs and other stakeholders. So it's a great mix, and I'm delighted to do that sort of outreach side of things here today.
Yeah, well, thank you. We appreciate that. We appreciate you being here with us today. And as we sit right now, there are 4 commissioners. There are 5 seats, but 4 commissioners right now. And the 5th what do we think the timeline is on having a full complement of 5 commissioners?
Yeah, so right now we're 2-2. My former colleague, former chair Dylan, who was a Trump appointee, Republican, she just recently finished up her term at the end of the year. So now we're 2-2 split Republican Democrat, and the pending Democrat nominee just got renommed by the president in this month. And I am expecting probably a fairly fast confirmation process given the way the Senate is. So you may see a full complement this spring, if I had to guess. But the commission can continue to act even without a full panel of 5. We can act as long as there are 3, actually. So you will still see an active commission, but I do think you'll probably see an even more active commission in terms of affirmative policy documents, more aggressive litigation, that kind of thing, if the power balance switches 3-2 Democrat, Republican.
You mentioned something there in terms of policy documents, and I have Commissioner Lucas and I shared an agenda, and I'm going to go slightly out of order because you mentioned the policy documents. One of the, and maybe I'm mixing my terminology up just slightly, but in terms of guidance that we get from the EEOC, one of the guidance documents that employers and frankly maybe some employees have been expecting for a while is additional guidance on sexual harassment. Commissioner Lucas, do you think that's going to be the next big guidance document, if I'm using, again, the right terminology, please correct me, that we're going to get from the EEOC, or maybe something else like anti-Semitism is a hot topic? That could be a guidance document. What do you think we should expect in?
Yeah, so I sort of previewed this a little bit at my beginning of my spiel, but in terms of guidance documents, there's 2 kinds of them. One is a formal policy document. It's what people mostly think of as guidance, and that's going to be put on the agenda by the chair and then voted through by full majority vote. And that acts almost akin to a regulation, right? Under the rule on rules at the EEOC, that's a little in the weeds, but the point is we have a regulation that makes us deal with a formal policy document to the same degree as a regulation. So it's essentially regulatory action. And then there's sub-regulatory action or sub-sub, which might be a technical assistance document. So the chair issues that category of documents, and she has been active in a variety of guidance. We saw the COVID as a disability, technical assistance in the last year. We saw AI and disability coming out, but all of those are technical assistance. They weren't voted through. So just something to think about there. In terms of full voted through guidance, we haven't put out a reg agenda for a little bit. That's another issue. But the chair has certainly signaled that she's very interested in pushing through harassment guidance. And I should know that it probably would be broader than sexual harassment. It would just be harassment in general and updated harassment on all bases. So I don't want to, get out ahead of my skis because the chair does control the agenda here. But based on, what she said publicly, I think you should anticipate that when she has voting power, that's something she'll probably want to move quickly. And that's likely to be the largest big guidance document you would see coming.
Another big document that's in the works is the strategic enforcement plan. Commissioner, could you talk to the folks about what it means to have what does it mean for the EEOC to put out a strategic enforcement plan? What is it? And then we can get into some of the granularity of what are some of the areas that the EEOC is going to focus on.
Sure. So all agencies are required by law to have strategic plans, and most of them just have a strategic plan. The EEOC split it apart and has a strategic plan and also a strategic enforcement plan. So they're documents that held the agency accountable to Congress, to other regulatory agencies for just basically good government. And then specifically the strategic enforcement plan, which is out for public comment right now, also directs the priorities and focus for our litigation enforcement program. So while I think a lot of people will be focused on signaling the kind of litigation that the agency brings, it's also going to determine the kinds of large scale or more intensive efforts at investigations that are going to be going on. So those will include things like commissioner's charges, directed investigations in the ADEA and the pay space, to what degree various field offices dig in deeper into an investigation of a charge, to all the things that come before you get to litigation. So really it's the whole scale of enforcement activities. And it also should also drive the kinds of outreach events that we're doing. So really it's just signaling loudly the full commission's views on the various priority issues that are before it.
So can we go through a couple of the priority issues right now? And
Sure. And I'll also add the caveat that, this was a document that's been the process of, a career and political working group for about a year, but it wasn't voted through by the commission. So this doesn't necessarily reflect what the final version will be, or necessarily even the final approval of the commission is currently constituted. So we're getting public comments, and then the commission will eventually vote on this. But it's just something to keep in mind, that this isn't something that the commission voted to put out yet.
Right. And this is, and folks, this is still, it's like Commissioner Lucas said, it's open for comment. Nothing's final yet. So what we're talking about today may not be the way it is a couple months from now, but
directionally though, directionally, it certainly tells you where the chair is particularly interested in going. And like I said, so she drives the agenda, that it is an important document to take a look at.
Okay. So first area we'll focus on, and this is something that is recurrent in strategic enforcement plans, at least the last few that I recall reading, and that is protecting more vulnerable workers from discrimination. So at times that has been younger workers, maybe, I tend to think of employees at, who work at fast food restaurants, right? Who may not have much experience in the workplace, who may get exposed to different types of harassment that they hopefully haven't endured before and won't endure subsequently, but maybe they may not be in a position or know exactly how to address it if they are exposed to certain forms of harassment. And the EEOC would come in and help folks that don't necessarily have the experience or voice to speak for themselves. So also in that category could be immigrants who may be taken advantage of in the workplace. But here, some of the subcategories that are listed in the strategic enforcement plan are folks with intellectual and developmental disabilities, individuals with arrest or conviction records, LGBTQI individuals, again, temporary workers, older workers, individuals in low-wage jobs, and persons with limited literacy or English proficiency. I'm wondering, given all of these different categories, do you anticipate that the EEOC's focus will be on a more kind of systemic, focus on systemic issues versus individuals who fall within these subcategories who believe they've been discriminated against?
I think it's always going to be a mix. I mean, there's ways to help with vulnerable workers on a kind of case by case, a single individual situation where it's particularly egregious and particularly vulnerable individual, and sort of make note of things. And then there are going to be others that are just more of like quasi-class, a large group of vulnerable workers. And then sometimes you're going to have situations where it is systemic. I think the administration in general is very interested in what they term as justice involved persons. And historically in the Obama administration, you saw a focus on background checks. So it's possible that you'll have some focus on that, where you're talking about like a systemic policy that addresses what the administration views as a vulnerable class of individuals. I think historical categories that will remain very important are the ones like that you've mentioned, low wage, younger aged, less experienced workers, especially in the fast food industry. We've seen numerous sexual harassment litigation authorized in the past 2 years since I've been on the commission in that space. Continues to be a significant problem. Some of those are often against franchises that have many locations. So we've seen, multi-million-dollar verdicts or settlements in that space. So that's not, it can end up being kind of a large dollar value kind of case, despite it involving lower wage, younger workers. So don't minimize that one, I think, in terms of watching for that problem. And remedying the things that are coming up that are leading to these many cases. And then monolingual migrant workers, where they're non-English speaking, are particularly often a focus for vulnerable worker cases. I think it'll be interesting to see how much the agency expands into, I think, spaces beyond that.
Yeah, it's like the agency in the past has shot its shot, especially at arrest records. There has been some guidance, again, I think technical assistance guidance. It went into court against, I guess it was Kaplan in the Sixth Circuit. I think it was Freeman, I want to say, in the Fourth Circuit, and they didn't fare so well because the statistics
there's some
didn't
formal
support.
There's some formal policy guidance that got struck down in Texas, so that would be the Fifth Circuit, but it's been challenged in a variety of locations too. But I will say, what's old is new again is, I think, what you should probably be expecting. Probably a lot of Obama era redux in terms of these kinds of things. In general, I think a return to 3.2 will mean more of a focus in general on systemic issues. And again, I think that can be completely appropriate. I think it just depends on where you're focusing. So background checks, I wouldn't be surprised at coming up as a renewed focus.
I see some, I guess this is sent to me as a direct message in the comments, and it dovetails nicely into the next part of the strategic enforcement plan, with the caveat that Commissioner Lucas is not I'm taking nothing away from Commissioner Lucas, but I know that Commissioner Sonderling, this is his go-to. We're going to talk about artificial intelligence. And one of the strategic enforcement plan focuses is on reversing employer use of artificial intelligence to target job advertisements, recruit applicants, or make or assist in hiring decisions where such systems intentionally exclude or adversely impact protected groups. This doesn't mean, well, let me ask it in the positive. Does this mean that employers have to stop using AI for hiring?
No, certainly not. I think that'd be foolish for any government agency. You can't stand in the tracks of technology. But as my colleague Commissioner Sonderling, who has really led on this issue, likes to remind people, we've got age-old, decades-old civil rights statutes, and they still apply even in a new fact pattern here. So just because something seems really novel doesn't mean that you don't need to be going through all the same steps of looking for bias and checking and be thoughtful. And you can't, just like you can't assume that you're not going to have any liability if you're using a staffing agency or some other kind of agent, a vendor, whatever it is. If your agent happens to be AI, you as the principal can still be responsible. So you need to treat it with the same level of responsibility and thoughtfulness as you do actions that you personally are carrying out, your HR people are carrying out directly. Don't think that you have less responsibility just because AI is involved.
The protected class that usually stands out for me, the trouble spot with AI, is age. Does that resonate with you? Is age generally the number one, I don't want to say the number one most likely protected class to be adversely impacted, or do you see other minority groups being affected by the use of it?
I think it depends on what kind of AI you're talking about. If you're doing sort of simple screen or filter outs, it's pretty easy to try to limit what date someone graduated from, a degree, et cetera. That's, a pretty obvious one. More complicated decisions or technologies are going to involve things like If you're monitoring productivity or you're doing a Zoom interview and you're assessing the person's trustworthiness based on facial expressions, in those cases, I don't think that you're going to see age as the primary impacted group. You're going to probably see, I think in particular, people with disabilities affected there. So, for example, if you're neurodivergent and you have trouble making eye contact, but eye contact is a key factor in the AI's decision about whether or not you're trustworthy, or are you lying or being evasive, then you could really be dinged on that for something that is simply a disability. If you have facial differences or limb differences, that, craniofacial differences that also could affect that kind of software. And we've even seen things like, the lighting can mean that the software has a less ability to read people with darker skin, for example. So I think it's going to be a pretty big range of people who could end up being impacted. It's going to be really fact dependent.
And those are great examples of where the use of technology has a disparate impact versus the intentional disparate treatment of any particular protected class. So for folks that are using or thinking about using AI, these are particularly important questions to ask of your vendor, right? You might want to prepare a checklist of things. You might want to run some samples and make sure that what the system is producing for you is a broad spectrum of employees that cross over into many different protected classes, so that you're not ending up unintentionally with a disparate impact claim. Pregnancy, that's another hot issue. We were just talking, Commissioner Lucas and I, before before we let people out of the waiting room. We were talking about a lot of hot issues going on early on in 2023, and the passage of the Pregnant Workers Fairness Act was a big one. Commissioner Lucas, does the Pregnant Workers Fairness Act, which essentially makes the duty to accommodate 6 in one hand, half dozen in the other with the ADA? I mean, would you agree with me? It's similar that way, the duty to accommodate now under the new law?
Yeah, that's most likely how it's going to play out. And that's another topic we can talk about later in the discussion. But all of the accommodation laws at this point are moving towards an even standard where you're going to have undue hardship, meaning significant difficulty or expense. The EEOC is going to regulate on the PWFA, so I don't want to get 100% ahead of my skis there. But that I think is Congress's clear intent to have something modeled off of the ADA in that space.
From your vantage point, again, just talking for you personally, Commissioner Lucas, and obviously not speaking for the rest of the EEOC, does the passage of the Pregnant Workers Fairness Act significantly alter how employers should be addressing pregnancy-related accommodations?
I think so, yeah. I think that it's something that the biggest thing I would say is you need now to be doing a total review of all of your accommodation policies. And that's going to be from how you message it to the actual administration of pregnancy accommodations. Lots of the accommodations are going to be small, but they'll have a massive impact for individual workers. And they are a significant enough of change that you really need to be very careful in this space. So previously, pregnancy was going to be a real patchwork. Lots of the employers here may be already dealing with some equal burdens to deal with pregnancy accommodation, depending on what state they're in. Lots of states have had this, but this is going to make a uniform standard at this point, replacing what previously was a patchwork of either state laws or two buckets of when you would have to have accommodation. One, if pregnancy rose to the level of disability, and there's a host of ways that could happen, but most pregnancy isn't going to be disability. If you've got significant pregnancy, hypertension, or preeclampsia, or severe morning sicknesses, disabling, you're on bed rest, et cetera. Those are more obviously going to be a disability, but there's lots and lots of ways that pregnancy can really fundamentally alter how you're kind of dealing with things, but won't rise to a formal level of disability. Previously, that wasn't covered. That wasn't a required accommodation, unless you fell into bucket 2, which was if there was a similarly situated employee. So it was always you'd have to be running through multiple different buckets. Now it's just one level. Are you pregnant? Yes. Okay. Then you got to get an accommodation if you need it, unless it's going to pose an undue hardship. Very simple. Very much modeled on the ADA, but now the test is just, are you pregnant and do you need this?
Right. And in that regard, it's very linear and very, to your point, it doesn't require all sorts of different, considerations of what are we doing for this gentleman who has a bad back, who is also in the same position, who, is that similar in their inability to work? It does streamline things a little bit.
And, I think it's generally viewed by, I think, a big array of both bipartisan as well as employer and plaintiff side uses. This is just going to be a win-win for everyone. It's easy, it's simple. And also, frankly, as lots of people are looking about ways to support women, this is a real tangible material way that you can help retain women in the workplace, often for not significant cost.
Exactly. Exactly. I mean, this was supported by everyone from the ACLU to the AFL-CIO to SHRM to the Chamber of Commerce. So there was uniform, universal support from what you would consider the business groups and what you would consider the employee groups. This is good. I agree. This is good for business. This is good for everyone. We're getting close to about halfway through. I am joined by EEOC Commissioner Andrea Lucas. We are talking about right now the strategic enforcement plan and some of the hot areas at the EEOC. Thank you all for joining us. Please make sure if you're tuning in live right here with us, you're one of the 221 participants. Thank you. Please take advantage of the chat feature. If you do, and Commissioner Lucas answers one of your questions, you get a free get out of jail card you can use at the EEOC to get out of at least one charge of discrimination. No, I'm sorry, I'm kidding. I can't do that for you. But please do ask your questions anyway. We'll try to answer as many as we can. And if you're watching this on YouTube, thank you. I have chapter settings down in the description below. So if there are particular areas you want to fast forward to that we're talking about today, please do. We hope you tune in for the whole thing. But if you like what you're seeing, click on like, subscribe to the channel. It helps grow and get the word out. We have a few questions that are coming in. One question gets into the Pump Act. I know that is outside of the EEOC's jurisdiction. That goes more before the Department of Labor. But is there anything that you can address briefly, Commissioner Lucas, about the Pump Act?
Sure. Yeah, the Pump Act is outside, but I would say that this is, paired with the PWFA, it's a time that you should just generally be looking at a lot of women-focused policies and accommodation policies in general. Do a full reboot and review of all of that. Check in with your lawyer. Keep your eye out for EEOC guidance more in this space. And I'll also flag that the PWFA, not only does it cover pregnancy accommodations, but it also covers childbirth and other related medical conditions. So you may see things like lactation covered in that space. Lactation certainly is related to childbirth and pregnancy. So I think stay tuned to whether or not that would be something that might come under our purview. Check out our existing pregnancy discrimination guidance, which already covers the PDA, which falls under Title VII, but still will give you a flavor of some of those things. And it's, a best practice to be considering whether or not you can accommodate something like lactation at the workplace. Other things to be thinking about, I think, are like very clearly covered in this space are going to be miscarriage related accommodations. That's a topic that a lot of people don't want to talk about, but it's something that's really important to me to raise awareness on. Pregnancy is often a topic that lots of people don't want to talk about in general. And then pregnancy loss of any type is one step further, but it's really important to realize that not only may you have employees who may need accommodation in that space, you also may be required to provide them. So thinking about benefits and accommodations in that space in general is a really good idea.
Abortion as well would fall under the PWFA, and we'll talk a little bit about that in the context of religious accommodations coming up shortly, just foreshadowing where we're going to get to. Another topic that's part of the draft strategic enforcement plan is preserving access to the legal system. So that focuses on if you have a separation agreement, for example, that has confidentiality provisions or non-disparagement provisions or language that would effectively chill an individual's right or just chill an individual generally from complaining about discrimination in the workplace. Most of us lawyers, hopefully all of us employment lawyers who are drafting these up, have carve-outs that allow people to go to the EEOC if they believe they've been discriminated against. You may waive your right to a monetary recovery, but this is an area preserving access to the legal system. What are some of the examples, Commissioner Lucas, that you've seen, let's say in separation agreements, that the EEOC may take issue with?
Well, you're right. It's certainly some level of confidentiality, non-disclosure, or just general participation, like waiver of claims. So pretty much any document, whether it's a separation agreement, a NDA, an employee handbook, any employment agreement, period, whether it's exiting or current employee that has something related to waiver of claims or related to non-disclosure, non-disparagement, or or confidentiality in general, you just need to be checking to make sure that you're preserving the person's ability to contact any government enforcement agency. The SEC is also very focused in this as well, but it applies equally to the EEOC. So they still need to be able to speak with the agency. They still need to be able to participate fully in it, in an investigation. It's okay to waive damages, but be careful about how you phrase that because, with the bounty issues in the SEC, it's something to watch for. But make sure you don't also forget about the fact that another area in this space that the EEOC is interested in is age-related claims. So that's another place where something can be overly broad or imprecise might be the better term to do it. So OWBPA, Older Worker Benefit Protection Act, ADEA waivers, all of those notices are often really essential and people can get very tripped up on them. It's a very technical area, but the EEOC does have some helpful guidance in that space, which you should check out because there's very little case law in this space, but because most of the time people don't litigate it because that's the whole point of it, right? For those of you who aren't as familiar about it, the whole goal is to be able to waive the claims. If you do it in the wrong way, then suddenly you no longer have waived your age claims because the entire waiver is invalidated for the age claims. So most of the time, no one litigates it because they've been successful, but you want to make sure you're complying with that appropriately. So I think just in general, things like that, we're going to see a lot of reductions in force coming up. Obviously, there's been a substantial amount of layoffs in the tech industry and in general. So anytime in a downturn, really be watching for age-related claims as well.
Yeah, I gave an interview the other day to Bloomberg Law, and as we're talking about this, the reporter was asking about some of the things that employers should prepare for, and for whatever reason, I don't know why it didn't come into my mind to bring up OWBPA. So we're going to add that here. We're piggybacking on that, and just something for again non-legal advice for people who are tuning into this. Just a general tip. Unfortunately, and it's happened more than once for me, I'll get a form that someone in-house, generally not a lawyer, has utilized or intends to utilize for a layoff. Unfortunately, they send it out to me or their employment counsel for a final review just to make sure, hey, this is what we intend to use for the person that we're laying off who is over 40. And then, I ask a couple questions. Well, are you laying off other people too? Well, yeah, we are. Well, it says in the form that they're giving them 21 days in which to consider the agreement, when now probably we're talking about an exit incentive program or some kind of termination program where you need to give 45 days. And then you also have to attach a schedule at the end that shows the ages and the positions of all the people who were selected for layoff and weren't selected for layoff. And basically, what was the thought process? You have to commit that to paper as to how the company decided to lay off these 5 people, but not these 7 people. So anytime you're doing a layoff, whether it's 1, 2, 10, more than, you get much more than that. Now we're talking about WARN, get an employment lawyer involved just to at least, give the blessing and make sure that everything is compliant.
And I will fight that the EEOC has brought an increased number of age discrimination claims, lawsuits in the last year or so. So that's, an increased focus. And I think if you see more layoffs, that trend might accelerate.
Couple of other things. One other item that is highlighted in the strategic enforcement plan is addressing discrimination influenced by or arising as backlash in response to COVID-19 and other local, national, or global events. In terms of COVID-19, let's just focus on that. And I know people hate when we talk about COVID-19. That's so, 2 years ago, we had weekly Zooms talking about all the different changes to COVID-19 and the Families First Coronavirus Response Act. This is not, we're not trying to rehash and bring up bad memories, but what types of discrimination claims are the most prevalent ones now, the charges that are being filed at the EEOC relating to COVID-19?
We are seeing, I think, a continued wave of just COVID related cases. Earlier on, we had a number that were focused on, immediate firings or harassment, mass usage, preventing someone in a paternalistic way from coming back to work at the very beginning of the pandemic. Sometimes it takes people a little time to get be willing to file a charge. Obviously, in the last year, in 2021, into sort of the winter of 2022, a huge wave. I mean, we're talking about thousands and thousands of charges related to religious accommodation and disability accommodation, related to vaccine mandates. Those I think are tapering off now, but whenever we release our charge data for fiscal year 2022, you'll see a very large proportion of those. I anticipate we'll probably see an increased rise of telework or continued telework related claims as, I think the rest of the country finally catches up with the return to work. And, I'm sure this is a national audience. So this can sound weird to some of you who may have been back to work for forever, or never really weren't in person. But, depending on the region, especially in some of the sort of blue states or the Amtrak corridor, the white collar workforces have taken a long time to go back to work. The government certainly has as well, in terms of in-person work. And so I do think that'll accelerate some of the sort of requests for accommodation related to telework. That kind of charge and cases may be picking up more.
Commissioner, you mentioned the request for religious accommodations. I want to focus on that, not just in the context of COVID-19, but I want to take it broader than that and then bring in the Supreme Court case that is going to be decided this term involving the standard for what constitutes undue hardship for religious accommodation, and then maybe talk a little bit about some of the recent lawsuits that have been filed against CVS, and there's other drugstores are in the crosshairs. But generally speaking, one of the comments I got from clients, and we were all working remotely, we weren't necessarily on Zoom, Commissioner, so I don't know if they were rolling their eyes, but I know sometimes I did, was during COVID, we would get requests for religious accommodations. And we know that people don't have sincerely held beliefs. It's impossible that everyone who seeks one could have a sincerely held belief that getting the COVID-19 vaccine is against their religion. Some, sure. All of them, no way. How should employers, or how much should employers, in the general sense, forget about COVID, someone asks for a religious accommodation, how much should employers probe the sincerity of the beliefs of someone seeking a religious accommodation? Or is that just asking for trouble?
It is asking for trouble. As a practical matter. As a matter of law, the EEOC's longstanding position, and which I agree with, is that you do need to exercise a light touch here. That makes sense given the fact that religion isn't your average protected characteristic. There's First Amendment considerations. There's other areas, it's a kind of a really long-standing protected characteristic in a way that some of them aren't there. So you just need to step lightly in general in this space. And it's also deeply personal. And the protection is very, very broad in terms of what is a religion. Also, there are an array of additional claims that can arise if you screw up the sincerity step. So not only could you find yourself with a failure to accommodate claim, but you could also find yourself with a religious harassment claim or a retaliation claim. So if you're coming at it with sort of assumptions that the person isn't sincere, or that this is just something political, or anything that really can kind of speak to bias, it's very easy if you haven't adequately trained your HR or your managers that they can quickly slip into a religious harassment claim, quickly slip into a retaliation claim for the person seeking accommodation, and screw up the accommodation claim itself. So it's an area where you do need a lot of training. And I think a lot of people had not taken religious accommodation claims as seriously as they had the requirements for the ADA. With the Groff case, which the Supreme Court just took up to consider this term, it's all the more imperative to really be thoughtful and rebooting your religious accommodation processes. Make sure that you're fully compliant and start treating it as you really always should have, but all the more incentive to treat it on an even footing with any other accommodation claim, because that's where the court's heading.
Yeah, that's exactly right. And so for folks who may not be familiar with the Groff case, just real briefly, Groff worked for the Postal Service, and Groff wanted an accommodation because of his sincerely held beliefs. I don't think anyone questioned the sincerity of his beliefs, to have essentially a flexible schedule on I believe it was Sundays, because it would conflict with his religious beliefs. I don't know if he was going to the church, temple, service, yes, some religious occasion. And the pushback was that, well, we have very few people who can work your job when you're not there. We're very tight shifted. And if you take this time off, it's going to impact morale of your coworkers negatively. So that was part of it. That was part of the reason why the employer denied the accommodation, because it would create an undue hardship. And part of the undue hardship, if you sort of connect the dots, is the impact that it would have on employees. And I guess you could say, well, if morale is bad for employees, that could adversely impact productivity. If it adversely impacts productivity, then you could eclipse what is an undue hardship. And currently, as the law stands, under the case of TWA versus Partisan, the undue hardship standard for religious accommodations is anything more than a de minimis cost is an undue hardship, as opposed to the Americans with Disabilities Act, which is a much higher bar. It really gets into more of a bigger financial impact on the company generally, or at the particular location where the accommodation is requested. And the lower courts applying the Hardison TWA decision said that the employer, the defendant, was in the right here, that there was an undue hardship, but Groff asked the Supreme Court to revisit the standard in TWA versus Hardison, and the Supreme Court has agreed to do it. Many of the justices have foreshadowed that they are going to change the standard. They are going to get rid of Hardison. To me, and this is just me talking, it wouldn't surprise me if it was unanimous that the court got rid of the Hardison standard. I don't think this is necessarily a partisan issue. The question then that I have for you, Commissioner Lucas, is, do you think that the Supreme Court will establish a new standard that aligns with the ADA, or is it possible it could exceed the undue hardship standard under the ADA for religious accommodations?
I think it's unlikely that it's going to exceed that standard. It's possible that you might have, I think you're right that it's certainly going to be a bipartisan decision to change the standard and increase it from the Hardison level, which is, almost a nullity. And you had bipartisan dissent to the Hardison decision way back in the 70s or so. So it's probably going to be a bipartisan decision. You might have a few justices that would be willing to have something higher, maybe. But I think that they wouldn't be able to win a plurality. So I think the most likely outcome, especially previewed by Justice Gorsuch's dissental, a dissent from denial of a cert petition a couple rounds ago in terms of challenging the Hardison decision, a real focus on the undue hardship standard that is present in a bunch of different statutes. So he ran through the fact that all of these different civil rights statutes that have come after Title VII, and that's going to include the ADA, but also things like ACA, right, the Affordable Care Act, and even USERRA. All of them have an undue hardship standard. All of them measure it by the same standard, which is significant difficulty or expense. So his focus on that, I think, probably would be a centrality opinion. So you're likely going to have a standardized hardship standard. So everyone probably should be preparing for that. And that's also, going to be probably the standard under the PWFA as well, if it isn't already clear. So, generally speaking, all of your accommodations should probably be on a same footing going forward.
Maybe this is more harkening back to your days at Gibson Dunn. Do you have any non-legal advice for employers as to how they can proactively establish that an accommodation request, whether it's a religious accommodation request, one under the PWFA, ADA, creates undue hardship? What should they be thinking about proactively?
Yeah, I think you really want to have built a record, right? And that's both to make sure you're fully compliant as well as to minimize liability, right? It's just doing this right. And sometimes you're going to find that as you build the record, you don't actually have the record, right? And you really need to accommodate this person, and it's a way to do it. So it's really vetting it out, looking and seeing whether or not this has been done in other cases and trying to figure out the cost of it, trying to make it tangible in any way, really going through a robust interactive process. That's a step that a lot of people skipped or didn't think they had to do in the religion space. But you have to do in the ADA, and you really should do it in the Title VII space as well. And for, again, all accommodation stuff. So if you're actually going through the interactive process, you're likely going to start being able to particularize what does this accommodation actually look like. Anything that is deals with a realm of individualized and specific and tangible, you're going to have a lot better shot of just weighing it either direction, right? This isn't an answer that you won't always get the answer that maybe you were hoping for, but hopefully you'll get the right answer if you're going through a careful, thorough, individualized assessment.
And folks, err on the side of giving the accommodation, right? And it goes without saying, yes, you can ask for medical records. Yes, you could ask to confirm that someone is pregnant if you can't already tell, but the focus should be, as Commissioner Lucas said, not so much on the underlying disability or their religion, but rather on the interactive process and the ability to accommodate. And more likely than not, I think you'll find that you can come up with a reasonable accommodation that allows the person to perform the essential functions of the job. But speaking of performing essential functions of the job, and we're talking about religious accommodations, I want to talk about a spate of recent lawsuits that I alluded to today in the blog post promoting today's Zoom, including 4 against CVS Minute Clinic subsidiaries involving the alleged failure to provide religious accommodations to employees who refuse to prescribe birth control pills and abortifacients or otherwise refuse to perform some of their job functions for religious reasons. Now, each of these cases is going to be different. I know one of the lawsuits I read today, allegedly, based on the complaint, CVS had a history of accommodating people who could otherwise be in a position of having to prescribe birth control and not making them do that. They could pass that off to someone else, and then they allegedly changed their corporate approach to how that was going to be handled. But more generally, because people, not everyone who's joining us today works for a large drugstore, what steps can employers take to ensure that employees who require these accommodations, we'll say religious accommodations, can still perform the essential functions of the job, right? I'm thinking, if someone needs a teacher who needs every Friday off to go to observe their religion, that might conflict with regular attendance being an essential function of the job. So what are some of the things that employers can do to ensure that employees can perform the essential function of the job if they need accommodations?
Yeah, I think the important thing is to make sure that you've actually defined what essential functions are and try to put that in writing. But you see that in the CVS cases, the documents that are out there that are public, indicate that CVS did try to define that. What I would counsel you to be careful about is if you are defining an essential function in a way that is designed to prevent someone from getting an accommodation, you could have some issues with targeting someone. So if you'd been a 4-day-a-week, school's not probably the right example, but if you had never really required people to be in the office on Fridays, and then suddenly that you've got a group of Muslim workers, all who would like to have time off to go to their do their religious services, and then you suddenly decide that now you must be in the office on Fridays, you could have some religious targeting concerns there. And that is the allegation in the CVS cases, which I think is quite troubling. The pivoting having not only a disparate impact on certain individuals with religious accommodation requests, but also the possibility that there was some intent behind their changing essential functions rapidly. I think you run some risk, and you should also just be really thoughtful about whether or not it is in fact an essential function. The EEOC in the ADA space has some guidance on this, and you're likely going to see that increasingly applied in other spaces that are dealing with accommodation. So the things that you should be looking at are, if the reason the position exists is to perform that function, the number of other employees that are available to perform that function, or how it's distributed amongst them, whether or not it's really a central core or it's a minimal part of the job, the time that's spent performing the function, the consequences of them not performing the function. So, attendance as a teacher seems pretty core, right? But something that is a small percentage of someone's time, and there are other people who can do it, it's going to become more and more tenuous. And the more and more tenuous it is, the more and more likely you're going to have trouble on pretext about whether or not you were kind of claiming that it was an essential function to prevent someone from having an accommodation. So that's where you really need to have care there.
Speaking of tenuous, I want to come full circle, and I'm going to ask a difficult question. One of the issues that the Supreme Court left open in the Clayton County case a couple of years ago, which clarified that sexual orientation is covered under Title VII as a protected class. They left open the issue of, well, maybe there could be some kind of friction between someone's religious rights and discrimination against LGBT workers. So how might the EEOC address tensions between, let's say, Title VII's duty to accommodate or religious bias generally and Title VII's protections for LGBT workers? I'm thinking, like, the example that would come to my mind is someone who has transitioned and they're now being misgendered intentionally because someone's religious beliefs conflict with calling, someone he or she who has transitioned. How do you think the EEOC is going to address those tensions?
Well, I think some of that will depend on the composition of the panel. And there's, strong disagreement, I think, on the commission about how you might balance that. From my own perspective, my viewpoint is that we have multiple protected characteristics and they need to be in generally an even footing. And this kind of balancing happens all the time. And think about it in the ADA space and a religious accommodation. imagine someone who needs, a passenger needs to have a service dog to ride in a taxi, but the taxi driver, the employee of the business is Muslim, and there are cleanliness issues with being there. How do you balance your rights under the ADA and religion? And I think from my perspective, the key takeaway is you can't prioritize one over the other. We're statutorily bound to recognize all of the rights. So trying to find something that balances it and doesn't automatically assume primacy of a particular right is important. And that's something important to step away from your biases, and to the extent that a particular political viewpoint is a little bit more in vogue or accepted by majority discourse, or a religious viewpoint is controversial or hard for most people in the culture to not understand, it doesn't give it any less rights. So when you're the employer thinking about these things, you need to try to find a balance as much as possible. You can't kind of pick one or the other. How that's going to play out will really be very, very fact specific. I will also note that, the Supreme Court did leave open the question of something in the gender identity or transgender or sexual orientation space, really beyond termination and firing, hiring. So it didn't go into pronouns or bathrooms or dress codes, and left open the question about whether or not any of those things actually would constitute unlawful discrimination as opposed to disparate treatment. So that's an open question too, not just the balancing of religious rights, but also sort of the application of those, even in the absence of any countervailing religious interests. The chair has obviously taken some positions on that, and we may see the full commission, in terms of a majority vote, take some more positions on that. But as of now, the technical assistance that the chair did on that has been enjoined in some jurisdictions.
Texas, yeah. Nationwide, correct?
Right. It vacated in Texas and enjoined in 20 states. So okay. It's been removed from the website. It's an open question about how that'll apply. But the point is, it's still really unsettled. So in the absence of settled considerations, I think your best idea is to try to find a happy medium and not preference one employee over the other.
Well, folks, we're getting close to the top of the hour. What are some of our takeaways today? Take a balanced approach, individualized assessment in terms of accommodations, no matter what the undue hardship standard is. And things are going to be interesting in a good way at the EEOC. So stay tuned. If you haven't connected with Commissioner Lucas yet, let me make sure I put it in there twice. I'm going to put our contact information down in the chat. I want to thank everyone for attending, and I want to thank Commissioner Lucas for her time today. Commissioner, anything you want to plug? Anything? I usually give that to the guests. Anything you want to plug? Anything going on? Fun in your life? Who are you rooting for this weekend? Who's going to win?
Hopefully getting more sleep, because I got little children. But I'm keep your eyes close to the EEOC on all the pregnancy related stuff, because it is the first new law that we've had since the ADA Amendments Act. So hopefully some activity in that space. And I think, pregnancy accommodation is a really bipartisan issue that's shared by everyone on the commission. So I'm excited to see how we can help people in that space.
Perfect. Well, folks, if you are hanging in there for the last couple minutes, or you got here late, or you saw something and you want to see it again, check it out on YouTube. I will post the link on Monday in the blog. I'll put it on LinkedIn. Hopefully you're already subscribed to the YouTube channel, so you'll get the automatic alert when it gets posted sometime this weekend. But I may be a little bit distracted if I don't get to it today, and certainly by tomorrow night, because I'll be watching the Eagles take care of the Giants. And hopefully we'll play the 49ers in the championship game, because I root for whatever team is playing the Cowboys. But folks, thank you again for your time today. We appreciate you. Enjoy the rest of your day. Have a great weekend. Thank you very much.